Thank you. You really didn't have to stand up. Miss Richards does.
I should perhaps explain that the chair's new location is not because I'm about to start cross-examining him, sadly. I want to start by saying something about the inquiry's work over the last 4.5 years. I'm then going to say something a little about the inquiry's work after today, because today is not the end. And finally, I'll make some observations about just a few of the issues that have emerged from the oral and written submissions that we've been considering over the last few weeks. The events which gave rise to this inquiry have memorably been described as the worst treatment disaster in the history of the National Health Service. The scope of this inquiry has been unprecedented in what I would suggest are 4 particular respects. Firstly, as to the scale of the disaster. The number of those infected runs, as we now know, into tens of thousands, many of whom have died. And as we have been powerfully reminded during the submissions, not least yesterday and this morning, people are continuing to die in consequence of their treatment with infected blood and infected blood products. Secondly, the inquiry's scope is unprecedented in terms of its geographical scope, covering all 4 nations within the United Kingdom and giving rise, as you've heard this week, to considerations about the relationship between the UK government and Scotland, Wales and Northern Ireland, both pre- and post-devolution. Thirdly, the scope of the inquiry is unprecedented in terms of its time frame, exploring over 5 decades of knowledge, of decision-making, of action and of inaction. And then the 4th respect is this. Most inquiries examine a catastrophic event and the circumstances, which may often be complex, which lead up to that event. This inquiry's terms of reference have required it to consider the response of government, the NHS and others in the decades following the transmission of infection. Mr. Dawson Casey yesterday talked about the way in which the harms caused by infection and treatment have been, and I quote from his submissions, irrevocably and multiply compounded and increased by the way the state has reacted. And he described the compounding of the harm as a unique and important element of the disaster, which you, sir, will have to consider. It is important that the wider public and the media understand that this is not simply an inquiry into matters of history. This is an inquiry into, as Mr. Williams Casey put it on Wednesday, the here and now. It is an inquiry with ongoing relevance and resonance to decision-making by government and the NHS today. In the last 10 days, 3 reports have been published. On the 24th of January, the Committee on Standards in Public Life published the report that its chair, Lord Jonathan Evans, told us about when he gave evidence to this inquiry in November. That report is about the need for active work to ensure that the ethical values reflected in the Nolan Principles become the cultural norm for those in public life, the inference being that there is still more work to be done in that regard. And you may think one only has to read the news to believe that to be the case. The second report, published this week, is a report from the College of Policing and the National Police Chiefs Council, entitled The National Police Response to the Hillsborough Disaster. It's a response to Bishop Jones's report, about which you've heard a lot over recent weeks, his report entitled The Patronising Disposition of Unaccountable Power. And that police report accepts that those who lead must acknowledge when mistakes have been made and must not seek to defend the indefensible. The third report, just published, is a report from the Patient Safety Commissioner for England, Dr. Henrietta Hughes. She's just reported on her first 100 days in post. It makes depressing reading. She says this: Over my first 100 days in the role, I have heard a yearning desire for patient safety to be at the top of the agenda. It is clear from what they told me that the focus of the health service is on productivity, operational performance, and financial control. She said this, and this is a sentence which I think will resonate with all of you. Medicine is industrialized when it needs to be humanized. She said also this, worryingly, it is clear that the culture is getting worse, and unless leaders set a strategic intention to listen and act, we are heading straight back to the days of mid-staffs and other health scandals, severe harm and death. Turning then to the inquiry's work. In order to fulfil its wide terms of reference, the inquiry has had to gather a vast amount of material. It's had to obtain, sift and analyse contemporaneous documentation from a wide variety of sources, and then use that documentation to obtain statements from a large number of witnesses. It is only right that I should acknowledge that the inquiry has had extensive cooperation from core participants and their legal representatives, and I should say that has included the Department of Health and Social Care. And we are grateful for the amount of work that's been devoted by witnesses to the task of engaging with and responding to the inquiry's requests for documents and statements. A few facts and figures then about the inquiry's work. The number of documents disclosed to core participants is, I am reliably informed, over 100,000, comprising over 750,000 pages of material. We have received over 4,000 statements from those infected and affected. We have received well over 1,000, I think the precise figure in fact is 1,200, statements from other witnesses, so doctors, politicians, civil servants, those involved in the Alliance House organisations, those working for pharmaceutical companies, and so on. We've obtained material reports from 7 different expert groups, and I'll refer to some of those in the course of my address. The inquiry has heard orally from 370 witnesses and has sat hearing evidence and submissions for 286 days, including today. I hope you don't mind if I give you a quick recap of what we've covered in the oral hearings. Following the preliminary hearings in September 2018 at Church House in Westminster, we heard the evidence of people who were infected and affected. Starting in London at the end of April 2019, we then moved to Belfast, to Leeds, to Edinburgh and Cardiff, and then again sat in London in October 2019. In February 2020, the inquiry heard from the intermediaries who were able to tell us about the experiences of those who'd not felt able to give witness statements to the inquiry, but who wanted their story nevertheless to be heard. We heard from clinical experts in relation to hepatitis, HIV, and on bleeding and blood disorders. And we heard from the psychosocial expert panel. Mr. Dawson told you yesterday of the importance of that evidence from his client's perspective. That evidence helped all of us understand the multiple and profound ways in which lives have been impacted above and beyond the devastating direct consequences of infection and treatment. I just want to read one short passage from the evidence of the psychosocial experts. It was on the 24th of February 2020, and it's page 150 of the transcript. The question which I put was as follows. One particular feature from the evidence that the inquiry has heard is that for many people, their whole lives have become defined by the condition with which they were infected and treatment for it, the symptoms and so on. But the result is that they have had to live a life completely different from the life that they would otherwise have expected to. And they have lost opportunities, been unable to fulfill a potential that would otherwise have been there. How does that bear upon their psychological experience? And this was Professor Weinman's answer. Hugely. Because, he said, going back to what I was talking about earlier, about one's sense of self, one's sense of self-identity, I think some people have said, if you think of illness as a sort of set of things and oneself as a set of things, and for some people, the sense of oneself can be completely obliterated. Because day to day, this is what's happening to you. There is nothing else. So those multiple selves, one's future selves, all those really important dimensions become pretty well wiped out. That is, from an experiential point of view, but also in terms of people's aspirations, absolutely devastating. The idea of having, no obvious future or incredibly uncertain future, which is completely dictated by this thing which now defines you, it's massively impactful. So I know that the psychosocial evidence will be hugely valuable to you in your work of addressing Part 4 of the Terms of Reference. Returning to the oral hearings, it had been the inquiry's plan to start hearing from haemophilia clinicians in the summer of 2020, but as we all know, events took a different course and the pandemic intervened. That led to those hearings being deferred to September 2020, but since that time, the inquiry has managed to continue to conduct its hearings, notwithstanding the constraints imposed by COVID-19. The September 2020 hearings began with the evidence of Lord David Owen. His important evidence was then followed by an examination of medical and other literature so as to analyse, and importantly, expose to public scrutiny, what was actually known and what could or should have been known about the risks of viral transmission at the relevant times. We also began the first of a series of presentations. We started by looking at the work of Professor Arthur Bloom, the Cardiff Haemophilia Centre and the Oxford Haemophilia Centre. Such presentations are not a normal feature of the way in which public inquiries normally hold their hearings, but it had seemed to us important, where there was no living witness, that the key facts and documents should be examined in a public domain for all to hear. We heard the first of a number of haemophilia clinicians starting in October 2020 with the evidence of Dr. Mark Winter. We heard from a number of other clinicians over the following months, and where we were not able to call key doctors, we continued to examine the contemporaneous documentation and presentations. We heard from the expert panel of medical ethicists in January 2021. I'll come back to their evidence, but again, it's hugely important evidence from the inquiry's perspective. We heard from Mr. Waters of the Haemophilia Society and evidence from those involved in the Alliance House organisations through February and March 2021. In May 2021, we heard from health ministers in each of the 4 nations, together with those involved in the current financial support schemes. I am sure you will all recall Mr. Matthew Hancock, then Secretary of State for Health, accepting moral responsibility on the government to address the impact of what happened to you. And he said this too: should substantial compensation be the outcome of this inquiry, then we, the government, will provide it. In June 2021, having heard further evidence about the Haemophilia Society, we heard evidence from campaigners, and we examined and called evidence in relation to laws. I do not think I am in any sense prejudging the conclusions you reach, sir, when I observe that the evidence that we examined and heard in relation to laws was truly shocking. In July 2021, we heard the first of our government witnesses, civil servants and politicians, Dr. Diana Wolford, Lord Glenarthur, and memorably, Lord Clark. I am sure you will all understand when I say I am unlikely ever to forget the experience of questioning the latter. In September 2021, we had the evidence of Lord Fowler, which you may think set a rather different tone. And then between September and November 2021, we examined the actions and roles of pharmaceutical companies, largely through presentations and analysis of the contemporaneous documentation, but we heard also from Christopher Bishop, an employee of Armour. In November 2021, the inquiry turned its forensic lens on the blood transfusion services, and that work continued into February 2022. As well as presentations on the organisational structures and history of the blood transfusion services, we examined the work of Dr. Gunson and Professor Cash. We were able to hear from a number of surviving regional transfusion directors. Fortunately, this was an area in which we were able to hear directly from those involved in Wales and Northern Ireland, which has not always been the case. And that phase culminated in the evidence of Dr. Lloyd, the Newcastle Regional Transfusion Director. You will recall, no doubt, that in 1991, he had been vilified for having the temerity to introduce hepatitis C screening ahead of other regional transfusion directors. In February 2022, we undertook the vitally important task of examining blood transfusion policies and practices through presentations and witnesses. We moved in March 2022 to consideration of self-sufficiency, domestic production and viral inactivation, hearing from Drs. Foster, Snape and Perry. In May 2022, we returned to government decision-making, mostly hearing from witnesses from England and Scotland, a range of civil servants and politicians, predominantly health ministers, but also a former Prime Minister, John Major. That took us to the end of July 2022, but of course also in the course of July of 2022, we heard the evidence of Sir Robert Francis, nearly 7 months ago now. Following further government evidence in September 2022, the inquiry hearings moved into their last phases. Between September and October, we returned to the vitally important exercise of hearing from those infected and affected directly. We heard expert evidence from the Public Health and Administration Group, evidence from Professor Richard Tedder, and then in November, we moved into 2 weeks of evidence relevant to recommendations, covering a wide range of issues and culminating with the evidence of Professor Sir Jonathan Van Tam. 3 short observations about the oral hearings. First, I must emphasise that whilst the inquiry has heard orally from a significant number of the infected and affected community, there are many more who did not give oral evidence, but who have provided written statements to the inquiry. Their evidence is just as important, and I know you, sir, have faithfully read those statements. Secondly, we must not and do not forget those who have died and whose testimonies we have never been able to gather. Those who've been infected but who have, for perfectly understandable reasons, not felt able to participate in the inquiry, no doubt perhaps in part because of their experiences of stigma and trauma. And those who may have lived and died unaware of their infection as a result of blood transfusion. Thirdly, in relation to the oral hearings, there are key individuals from government, from the medical profession, from pharmaceutical companies and elsewhere, from whom the inquiry has not been able to obtain statements, either because they are dead or because of impairments of health and age. Bloom, Gunson, Cash, Lane, Forbes, Willoughby, Galbraith, Aitchison, those are some of the names that come to mind. Had this inquiry been heard in the 1990s, most, not all, but most of those would have been able to give evidence. However, notwithstanding that disadvantage, we have, we think, been able to gather and shine a forensic light on sufficient of the contemporaneous documentation to enable you, sir, to answer the terms of reference comprehensively. If I turn briefly to the inquiry's ongoing work, the oral hearings come to an end today, but the work of the inquiry continues. That burden will fall largely on you, sir, and I know you'll shortly provide some further information in that regard. I won't try and steal your thunder. There are some witness statements still being received, and hence there will be some continuing disclosure of documents and statements to core participants, as well as a process of publication of a large amount of material on the inquiry's website. It's very much now an exercise of crossing T's and dotting I's, filling in very small pieces of the jigsaw, and we do not expect the material that we are continuing to receive to be likely to alter any of the submissions that have been made. If, however, there are any particular significant statements, I undertake to flag that up to recognised legal representatives, and if they wish to add to their written submissions, that can, where the Chair considers it would be helpful, be facilitated. I want to turn then to some observations relating to issues that have arisen in the course of the submissions hearings. But I'm going to preface them with a general observation. Section 2.1 of the Inquiries Act precludes the Chair from ruling on or determining any person's criminal or civil liability. But Section 2.2 provides that the chair is not inhibited in the discharge of his functions by any likelihood of liability being inferred from the facts he determines or the recommendations he makes. What that means, sir, is you are free to criticise. You are free to say that wrong was done and to particularise, if this is where the evidence leads you, the respects in which you consider wrong was done. You are free to say that governments or clinicians or NHS bodies or pharmaceutical companies acted unreasonably or unethically or unconscionably or failed to act when they should. With that in mind, can I then address 3 points that have arisen out of these submissions? The first is the nature of the obligation owed by the state or the government to its citizens. Although the chair is not empowered to determine questions of legal liability, as I've said, he is entitled to consider the nature and extent of the state's obligations and responsibilities to its citizens, and that may provide a useful backdrop to an analysis of what happened and why. Core participants in their submissions have identified 3 sources of obligations and responsibilities. The first are international and human rights conventions and instruments. They're discussed in some detail in Mr. Snowden's written submissions and in Ms. Monaghan's written and oral submissions, and I don't propose to repeat them. There's only one additional matter which I flag up. Ms. Monaghan, in paragraphs 30 to 31 of her written submissions, described one particular protective obligation under Article 2 of the European Convention, that's the obligation to protect life. And the obligation she described derives from a decision of the European Court of Human Rights in a case called Osman. It's an obligation often referred to as the operational obligation. But there is a separate and additional obligation under Article 2 that you, sir, may wish to consider. It's referred to in the case law of the European Court of Human Rights as a systemic obligation. It's a duty to make regulations compelling hospitals to adopt appropriate measures for the protection of patients' lives. A duty to have effective administrative and regulatory systems in place, and a duty which encompasses necessary measures to ensure the effective functioning of the regulatory framework, including by way of supervision and enforcement. You may think that those formulations of the state's duty to protect life have a particular resonance to this inquiry's work. One other source of responsibilities and duties identified by core participants in their submissions are domestic legal duties. Mr. Snowden's submissions take you, sir, to the National Health Service Act of 1946, 1977 and 2006. I don't propose to rehearse those. But you will no doubt need also to consider the position in relation to Scotland and Northern Ireland, because those acts cover England and Wales. But the third source of state responsibility is what might be characterised the moral duty. Lord David Owen, when he gave evidence from his perspective as a health minister in the 1970s, and his evidence was given on the 22nd of September 2020, was asked this by you, sir. As a matter of principle, do you see it as one of the first duties of the state to look after the safety of its population? Answer, yes. Question, so that would extend to the safety of patients receiving blood or blood products? Answer, yes. Exactly 1 year later, on the second day of his oral evidence, Lord Fowler was asked a similar question by the chair. Would your standpoint have been that keeping the public safe is one of the first, if not the first, duty of government? Answer, I think it is the first duty of government, and so I would take public health as being the first. Question, and therefore everything ought to depend first of all upon, does this protect or help protect the safety of the public? Answer, exactly. And then Andy Burnham, who gave evidence in July 2020, was asked about his own words in a document called Glaziers and Window Breakers. The reference for the transcript, it doesn't need to go up, is RLIT 301140. It's a document that gathers together the reflections of a number of former Secretaries of State. And Mr. Burnham in that document had said this about the job of being Secretary of State for Health. The job, as I see it, is to get the best possible health care the safest, highest quality healthcare for the people of England and to protect them from health risks. And in his oral evidence to this inquiry, he said he would absolutely stand by that. Moving then to a second issue emerging from the submissions that have been made by core participants. You have heard about hindsight, and you have heard warnings about the risk of hindsight bias. It's been suggested that the decisions and actions should be assessed, at least in the first instance, by the standards and norms of behaviour or conduct at the time. And that's a suggestion not limited to the Department of Health and Social Care, but you'll see it also in the submissions of NHSBT, the Belfast Health and Social Care Trust and others. There are 2 points I would like to make in relation to that. Firstly, something may be done in accordance with the standards and norms of the time and yet be wrong. A stark historical example, but one that was referred to by the medical ethicists during their evidence, is slavery. You, sir, are not limited to assessing decisions and actions by reference to the standards or norms of the time. You are entitled to say that what was done was wrong, if that is where the evidence takes you. You are entitled to say, indeed, that the standards and norms themselves were wrong. The medical ethicists said this in their oral evidence. And in medicine, as in many other spheres of life, we can see examples of practices and behaviours that at one particular point were deemed acceptable, but subsequently with further thinking sometimes, and it's just with further thinking, it becomes clear that those are just not acceptable and were actually never acceptable. You may recall, sir, that I suggested to the ethicists that context and history might help us understand why something happened, why a practice took place, but wouldn't necessarily provide a justification or excuse for that practice having taken place. And Professor Savulescu said, that's exactly right. There's a distinction between 2 kinds of reasons, explanatory reasons and justificatory or normative reasons. So, for example, a culture of paternalism or a dearth of guidance from the Chief Medical Officer or the General Medical Counsel might be an explanatory reason. It might help explain why something was done the way it was. But that doesn't mean it is necessarily a justificatory or normative one. The second point in relation to this issue about hindsight and standards and norms of behaviour at the time, and this was alluded to by Mr. Dawson yesterday, there is evidence before you, sir, that some of the ideas or principles or ethical norms that are most relevant to this inquiry have in fact been incredibly stable across time. And I want to take 3 categories of people whose actions fall to be assessed and judged in this inquiry: clinicians, civil servants, and politicians. In relation to clinicians, the medical ethicists told us about fundamental moral principles or values that were stable and consistent across time. They told us by reference to a 1979 publication, Principles of Biomedical Ethics, about 4 principles: autonomy, justice, beneficence, in other words, the imperative to do good, and non-maleficence, do no harm. The ethicists agreed that a basic and fundamental principle of clinical practice was that an adult with capacity should not be subject to medical intervention unless they had given a valid and informed consent. Their evidence explained that the philosophical basis for the idea of informed consent is patient autonomy. That is not a new idea. There was a discussion in the ethicist evidence about the 18th century philosopher Immanuel Kant. And Professor Savulescu said this in his evidence on the 26th of January 2021, referring to Kant's categorical imperatives of autonomy and rationality. He said this: because human beings have autonomy and they have rationality, you should always treat human beings as an end and never merely as a means. And how you treat somebody as an end is essentially if you get their informed consent, in a nutshell. So when they understand what you are proposing and freely agree to it, you are treating them as an end. When you don't, when you don't do that, you are treating them as a means. That's what's so important about obtaining informed consent, is that you're then treating the patient as an end in themselves and not merely as a means to something else. The ethicists also told us about the importance of a series of lectures given by Professor Sir Ian Kennedy in 1980, the Reith Lectures, Unmasking Medicine. And there's one of those lectures I just want to put up on screen. So, Lawrence, if we could have RLIT 40620. Reith Lectures 1980, Unmasking Medicine, Ian Kennedy, Lecture 4. If I were you, Mrs. B. If we go to the second paragraph, please. Professor Kennedy said this: it would normally be accepted that ethical principles, the principles by reference to which we organise our lives and decide what we ought or ought not to do, are not the preserve of any one group. But the doctor may reply that yes, he does make ethical decisions, but these are medical ethics, and so they are properly for doctors alone. This would suggest that there is a realm of ethics unique to medicine and within the unique competence of doctors to determine and apply. My response is that medical ethics are not separate from, but part of the general moral and ethical order by which we live. Decisions as to what the doctor ought to do must therefore be tested against the ethical principles of the society. He has no special dispensation to depart from our moral and ethical order. It must be wrong that a doctor, by describing a decision as medical, can claim unique competence to make such a decision, even if it touches the basic values by which we live our lives. And then if we can go please to page 3, Lawrence, second and third paragraphs. Professor Kennedy said this: another rationalisation resorted to is the so-called therapeutic privilege. This suggests that as a matter of good medical practice, circumstances exist in which the doctor may withhold information from his patient if in the exercise of his discretion and judgment it wouldn't be in the best interest of the patient's health to know. This is clearly a device created by doctors to do what is in the best interests of doctors. It may be justified on some occasions, but there is no effort to specify these occasions. Everything proceeds on the basis of the particular doctor's judgment. It all boils down to the doctor being good, gentle, and kind. It would be nice if all our doctors were like this. But just in case, can't we have some more certain guarantees that our interests, as defined by us, may be allowed to prevail? The device of the therapeutic privilege plays lip service to the principles of truth-telling and self-determination, while it creates a discretionary exception which is quite capable of swallowing these principles when the doctor decides the occasion requires it. If we look beneath these rationalisations, we see an ethical principle which is certainly not part of the received tradition in analysing the doctor-patient relationship. The traditional view is that the doctor-patient relationship rests on trust, or at least on agreement. But what we see is an operational principle defined by the doctor and accepted by us by default, which allows the doctor to suspend the trust or rewrite the agreement when in his view this is appropriate. Of course, if the patient breaks his trust or violates the agreement, there may be dire consequences for him, even to the extent of forfeiting his further care. Not so the doctor. He remains arbiter of the relationship, even to the extent of claiming the privilege of resort to an operational principle, which is the precise opposite of traditional ethics. And then this last sentence: for it is a basic moral principle of our society that we should tell the truth. Those, then, are some of the standards and norms of the time relevant to an assessment of the actions of clinicians. Turning more briefly to civil servants, the Public Health and Administration Group told us that the civil service attributes of integrity, honesty, objectivity, and impartiality formed the bedrock upon which the civil service was built. And that whilst those values were not enshrined in statute until 2010, the civil service had been firmly based on them for at least the last 160 years. So no need for hindsight in order to understand the values and norms which should guide the behaviour of civil servants. And likewise in relation to politicians, the same Public Health and Administration Expert Group enabled us to explore the Nolan principles, the 7 principles of public life. You'll recall they are selflessness, integrity, objectivity, accountability, openness, honesty and leadership. And although those were first formally published as such in May 1995, the experts told us that they were the principles that had long underpinned the spirit of public service in this country. So put shortly, the civil servants and politicians whose decisions and actions you, sir, will need to consider were always expected to act with objectivity, with integrity and with honesty. The third issue that I want to say something about it relates to the submissions that have been made about the position adopted by some of the public body core participants, most notably but not uniquely the Department of Health and Social Care. Much has already been said by, amongst others, Ms Gollop KC, Ms Jones, Mr Williams KC and Mr Steen KC. You have heard in the submissions of Mr Bowie for the Scottish National Blood Transfusion Service and the Scottish Territorial Health Boards that it is indeed possible for a public body to engage, even at this late stage, in a valuable process of critical self-analysis. As to the Department of Health not having a position or a case, Ms Gray was of course right when she said there is no compulsion on a core participant to formulate a case before a public inquiry. There's nothing in the Inquiry Act or inquiry rules that compel that. But one may ask the question, if a public inquiry is not the place for candor, what is? For years, of course, the Department of Health and Government, and indeed the devolved administrations, have promulgated positions and views. We've examined some of them. The phrases are familiar to you all. No conclusive proof, best available treatment, no fault, inadvertence. You, sir, may wish to consider the fact that the Department of Health and Government have felt able to take a position to advance a case previously on the basis of what might be said to be a limited understanding of the underlying facts. But now, when so much more is known, it has not done so. But that is, of course, ultimately a matter for you. I've already referenced Mr Williams' observation that this is an inquiry looking into the here and now. The position adopted by any public body and a disinclination, for example, therefore, to answer the questions posed of the department by Mr Snowden on the first day of the submissions, is itself a matter that you would be entitled to consider, if you wish, sir, as part of your assessment of the response of government under the inquiry's terms of reference. The other point to bear in mind about the situation of public bodies not engaging in the process of critical self-analysis is a point that was made powerfully by Mr Dawson yesterday. He referred to the psychosocial evidence and the evidence that a lack of apology, a lack of explanation can itself cause further harm. The psychosocial group told us how that can lead to healthcare becoming compromised because patients avoid going back into the healthcare system. They told us that people can become stuck with anger, that they can't move on with their lives because nobody has acknowledged or taken responsibility for what has happened to them. So one further question you, sir, will be entitled to consider as part of your analysis if you choose, in terms of analysing the response of government, is whether the stance of public bodies on an ongoing basis has compounded or continues to compound that harm. In that respect, it may be instructive to note that whilst the department might not wish to take a position, some of the witnesses who they have supported to give evidence have done so. Some, of course, have accepted where things went wrong. Mr Burnham gave evidence in very powerful terms in that respect. By contrast, however, we have the view of Lord Clarke in his evidence on the 27th of July 2021, if I may be forgiven for quoting. I don't think the department did anything wrong. I've never heard anybody suggest anything that in the real world a minister or a civil servant might have done that would have prevented it. I've already said, had we taken the step we now know would have saved lives, we'd have been treated with outrage by the Haemophilia Society and most haemophiliacs by denying them their factor 8. There just wasn't the evidence to suggest that. I don't think the department did anything wrong. I don't think that there was anything the department could have done that it didn't do. It's the current way of life now. It's part of the current political scene that somebody has got to be summoned, to use the old saying. Someone has got to be found to be blamed for this, and it's all the fault of the government, really, or sometimes it's all the fault of the Tory party. It depends who's in power at the time. I don't think we did anything really wrong. So you wanted the evidence which this inquiry has heard to begin and end with the accounts of those affected and infected. I'm going to end by reminding everyone about a particular piece of evidence that was heard during the course of the inquiry hearing on the 8th of May 2019. The reason why I'm going to do so, well, I'll explain after I've summarised the evidence. On that day, an anonymous witness, Mrs. C, gave evidence about her son, S. It was the first time she had ever spoken about these events beyond her immediate family. S was born in 1978. He had haemophilia A. He would go to hospital quite regularly to receive cryoprecipitate. He didn't like it. Mrs. C said it was quite difficult, but there was no suggestion from her evidence that treatment with cryoprecipitate was ineffective. In 1983, S's treatment changed to factor VIII concentrates and he started home treatment. In 1983. The significance of that date in relation to the events which the inquiry has been examining needs no further explanation. S was 5 years old when he began to be treated with factor VIII concentrates. I asked Mrs. C if she'd ever been given any warning about the products that her son was being treated with. Her answer, shortly, was none. She was just told it was an amazing thing. And indeed, it seemed that way to her because it was quicker and it was more convenient than cryoprecipitate. I asked her if there was ever any discussion with her about the particular concentrates being used or any differences between different kinds of concentrates. The answer was no. We don't know what particular concentrates S was treated with, but the annual returns for the hospital in question for 1983 and 1984 show the centre using both NHS factor VIII concentrate and ARMA factor VIII for home treatment. A year or two after S started being treated with factor VIII concentrates, he developed a tooth problem. Mrs. C took him to the hospital where they called a dentist to come down and examine him. And when the dentist appeared, she was wearing what Mrs. C could only describe as a space suit. The dentist didn't want to come too close to this little boy. He was 6, going on 7, and it was as if the dentist didn't want to touch him. Mrs. C didn't understand, so she turned to the doctor and asked what was going on, and the doctor took her into another room, gave her a blue plastic bottle and plastic gloves, and told Mrs. C that her boys, she had another son with haemophilia, as well as S, had been tested for HIV, had tested positive, and in future, when she administered factor VIII to them, she would need to wear the gloves and use the blue plastic bottle to put them in. Then the doctor sent them home. And that's how it was, said Mrs. C. The doctor didn't tell Mrs. C anything about HIV, or the connection with AIDS, or the longer-term prognosis for S and his brother. Mrs. C asked about the risks at home. She had a baby at home, but the only answer she got was that the doctor didn't know. Mrs. C hadn't known that her sons were going to be tested for HIV, and she never received anything in writing from the hospital about the tests and the results. About a week later, the GP turned up at the door with someone else, someone to do with education, she thought, and they said they had to go to the boys' school and tell them about the HIV results. There came a time when a newspaper reported that there were brothers carrying the AIDS virus in a London hospital. Their ages and the name of the hospital were given, but not their names. But Mrs. C knew that this was a reference to her boys. That information had, as she understood it, been leaked by someone at the hospital to the press. The inquiry was able to track down one of the articles before Mrs. C gave her evidence. It was said in the article that haemophiliacs had a higher than average chance of the virus developing into AIDS. Mrs. C told us the hospital hadn't told her that. The article said the parents knew of the risks to their children. She said that wasn't correct. The article quoted a spokesman for the Regional Health Authority saying the family was being counselled by senior doctors. They were not. When S was about 11, he was prescribed AZT. Mrs. C was not told anything about the side effects or the risks or disadvantages of AZT, and it had devastating implications and effects on S's health. She felt he was used as a guinea pig by the hospital. In early 1994, S became very ill. I'm not going to recount the details of his last weeks. It's in her written and oral evidence. But suffice it to say that he was very frightened and he was in a lot of pain. Mrs. C told us about a book that S wrote in, a kind of diary. It was entitled My Feelings and My Life. And he wrote on the first page, started 8th of February 1994. And he wrote finish when all the pages run out. S didn't get to finish the pages. That month, February 1994, was the month he died. He was 15 years old. There was no reference to HIV or AIDS on his death certificate. Haemophilia was on there, but not HIV, not AIDS. And that wasn't at Mrs. C's request. Because of stigma, Mrs. C kept S's diagnosis from her other children. She told them he'd had a rare form of cancer. But sometime later, one of her children was told by a doctor treating him at the hospital that his brother S had had HIV and AIDS and died from it. That was done without Mrs. C's knowledge and consent. And her daughter was given the same information by their GP. The family was never offered any support or counselling. S received some money from the McFarlane Trust during his short lifetime. The last Mrs. C ever heard from the McFarlane Trust was a letter with some money to help with funeral costs very shortly after he died. She learned that S had been tested for hepatitis C and been infected with hepatitis C only years later when a letter came out of the blue from the Skipton Fund. I just want to read 2 short sentences in Mrs. C's evidence. She said this: S did exist. He had every right to be here now. That was taken away from him. I think people should know what happened to him because it shouldn't have. Nobody's ever told me how this happened, why it happened, or just said to me, we're sorry. Mrs. C's evidence was about S, was unique to S, and was deeply personal. But I've recounted it today for 2 reasons. Firstly, because captured in that one account is so much of what you have all told this inquiry over the years. So much of what you've told us you and your loved ones experienced, whether infected through blood products or through transfusion, whether infected with HIV or hepatitis B or hepatitis C or all 3. The failure to provide information about the risks of treatment to the individual being treated, or in the case of a child, to the parent or parents. False reassurance, expressly or implicitly through the use of phrases such as wonder drug, about the safety of the treatment. The absence of informed consent to treatment. The absence of discussions about alternatives to treatment with blood or blood products. Testing for HIV or hepatitis C without consent. Failures, gross, appalling failures in the communication of diagnoses. The experience of stigma, including at the hands of the National Health Service. The terrible effects of the treatments, particularly the early treatments, whether, as in S's case and in other accounts that we have heard, treatment with AZT, or as so many of you have told us, treatment with interferon and ribavirin for those infected with hepatitis C. The unimaginable pain and suffering endured by those infected and witnessed by their families. Deep, abiding grief, whether for a life lost or a life whose course has been irrevocably altered. The lack of support, psychological and practical, and the lack of explanation, accountability, and apology. All that is in Mrs. C's account of what happened to S, and all that is in the accounts that you have given the inquiry over the years. The other reason why I wanted to recount Mrs. C's testimony is because I want to remind you of 3 lines to take that we have heard about, and suggest that it may be instructive to view those lines when you reach whatever conclusions you decide to reach so about them, through the prism of Mrs. C's evidence and the evidence of you all. The UK government line, and this is a quote, "The government does not accept that any wrongful practices were employed." The Scottish executive line, and this is also a quote, "No reason to believe anyone acted wrongly in the light of the facts that were available to them at the time." And of course, the line that we have seen repeated so often, and it's certainly articulated by the then Prime Minister, Mrs. Thatcher, in a meeting on the 22nd of November 1989, and the reference, I'm not going to put it up, is DHSC 302536_031. That a line that was then followed in the Northern Ireland office and the Welsh office. All patients received the best treatment available in the light of the medical knowledge at the time. Was S's treatment the best available treatment in light of the medical knowledge at the time? That's a question, sir, for you to consider. Very finally, in the course of closing submissions, thanks have been expressed to the inquiry and those working for it on its behalf. Those are greatly appreciated, and I can say on behalf not only of the team I lead, but I think on behalf of all those who have worked for the inquiry, that it's been an honour and a privilege and a truly humbling experience. But the true thanks are owed by us and by every government department, every government minister, past and present, every civil servant, every doctor, every NHS organisation, and every other organisation or individual with interest in these matters. To you. To every man, woman and child who was infected and who suffered. To every family member whose loved ones have died. Every family member who's had to witness and may still be witnessing their loved ones suffering in the most difficult circumstances imaginable. To those who have, with great courage, given oral testimony that has moved us to tears. To those who also, with great courage, have provided written statements to the inquiry which have revealed their most personal experiences and suffering. To those without whose campaigning, tenacity and determination there would be no inquiry. You have laid bare the most personal and distressing parts of your lives in pursuit of truth and justice, and in the hope that lessons can be learned for the future for the benefit of others. And so with the greatest of admiration and respect to you all, I say thank you.
Well, I say thank you too. I have to say, a personal note here, I could not have asked for a better counsel to the inquiry. And what she has said has shown once again the importance of this inquiry and the way in which there has been a response to that importance by the collaborative efforts, the collective efforts of all of you. Thank you. This is, in all probability, the last time we shall meet here at Aldwych House. The last time that those of you who have followed proceedings more remotely can log on to hear evidence, see presentations, or hear submissions. It may well be some time before we meet again. There's something perhaps, I'm going off script a bit here, but there's something almost like an end-of-term feeling about today. And forgive me then for being just the headmaster I've occasionally been and reminding you, please, particularly since there are so many of you here, you may want to take photographs. You know what's coming. Please be careful when you do, if you do, to make sure there is no one in the photograph who does not wish to be photographed, for obvious reasons, some of which you've just heard expressed. But you've been here, or there, throughout 4.5 years, through COVID, through lockdowns, through the challenges of ill health, through strikes, despite, in many cases, bereavement. Many of you have contributed through your statements, your evidence, your provision of documents. But let me stress that your being here or watching online in such numbers as you have has also been important. Let me tell you why I think it is so important. Nothing concentrates the mind of a speaker more than seeing and knowing that they're talking to a large number of people. True, a few may play to the gallery, no names. But for most, the knowledge that so many are so interested after so long a time tends to make them realize the importance of what they are addressing and the need to tell it as best they can. It also fully justifies the decision, even if belated, to hold a public inquiry. By definition, one in which the public has an interest. Your sheer numbers reinforces the point that the public think this is important. And it must help to bring that home to those who will in due course consider my report. Your simply being here has made a real contribution. Representatives of NHS bodies, the devolved administrations, politicians, civil servants, lawyers, clinicians, interested experts, Scottish, Northern Irish, Welsh, have also all contributed in their own way, I suppose I should add the English, to what I'd asked should be a collective endeavour. And in my judgment, it has broadly been that, even with the odd wrinkle. And I'd like to thank you, all of you, for that. Well, as you know, as Ms. Richards has kept reminding me the last half hour, I must now turn to writing the full report. Now, I can't tell you at this stage precisely when the report will be published. I wish I could. But I'll tell you what I do know, and it's this. The process of writing the report will inevitably take some time. Time to weigh the submissions with the evidence, time to resolve issues where the evidence is not clear-cut, and time to make the report as readable as I can. The report will not be short. Well, how could it be, given everything that we've heard? But it will be as short as I can make it, whilst doing justice to the evidence and the submissions which I've heard and read, and to the breadth of the terms of reference. And it will be as quick to produce as I can. Now, where there's a particular topic that interests you, I intend you should be able to go to the relevant chapter to find the answers you're looking for, and I hope that it will be an engaging read. There will, of course, be an overview so that you can quickly get a summary of my findings and recommendations, and so that members of the press can explain what we have collectively learned to the rest of the country. Beyond the writing of the report itself, there's a further part of the process which is required by statute. The inquiry rules require it, but I would, in any event, have considered it necessary in fairness. It is that where there is to be explicit or significant criticism in the report, and there will be criticism, that the person due to be criticised is told of what I intend to say and of the factual basis underpinning it, so that they can respond if they wish. Now, the process is not only fair, but it also reduces the possibility of challenge to the report. From the start, we've designed the inquiry's processes to avoid unnecessary delay at this stage. We've seen Ms. Richards and her team put areas of potential criticism to witnesses, both for them to answer in their written statements and in hearings. I don't anticipate that many witnesses or organisations will be surprised by the terms in which they are criticised, if they are. But I do have to allow a reasonable time for them to consider in confidence the criticisms that I propose to make, and for me to consider any responses received. Well, as we know, some of our witnesses are old, some are not in good health, and so I must make due allowance for that, particularly if there's more than one criticism to be made. But I can assure you that I will allow no more time than is reasonable. Now, I know that many of you will want to make plans outside the inquiry, and so I can say this, that the report will not be published before the autumn. Ms. Richards has persuaded me that July is likely to be too ambitious, and I think she's right, and that later in the year will be more realistic. It won't be August, since Parliament will not be sitting then, so in short, the best estimate I can give you is autumn. It's always been my intention to be as quick as reasonable thoroughness permits. Time is not a luxury I can squander. I assure you that I'll be writing the report as fast as I can, and that Ms. Richards and her team will be handling the warning letter process for me with their usual efficiency. I can also promise that we'll give you plenty of notice about when the report will be published, so that those of you who wish to come together and attend in person on that day are able to do so. Well, let me turn from the autumn to these last 3 weeks. First, I should say that the written submissions and these 3 weeks of oral submissions, mainly but not only from those who are representing institutions or groups of core participants, they've all been of great value to me. They've helped to highlight what has been most important to each of you. The written submissions have expressed it, the oral submissions have summarised it. I should add that if you'd asked me at the start of these 3 weeks whether each speaker would be able to contain what they had to say within their allotted time slots, well, you might imagine what I would have said. It's often much more difficult to condense, to précis what you think and why you think it. It's something of an art. I'm not sure I would have had it as an advocate, but I'm glad to say I would have, in this case, been proved wrong. And I'd like to thank each and all of those who made submissions orally for respecting, almost to the minute, the timetable. It was drawn up to ensure that the time available was shared fairly between everyone who wanted to speak, and by keeping within your slots, no one took unfair advantage, so thank you. Many of the submissions, in writing or orally, asked me to make another interim report about compensation. You heard that general point touched upon by Mr. Steen this morning. I'll need to reflect on the submissions, especially those that point out that as little time as possible should be lost before finalising arrangements for compensation. I want to tell you that I have written to the Paymaster General to inform him of my intention to make a further interim report about the framework for compensation. I anticipate that I'll be in a position to do so before Easter, if not earlier. We'll aim to tell you a week before publication when more precisely it is coming. The report will be shared with our contact list and published on the inquiry website. Finally, I want to come back to what I said when I started these few words. I would like to thank you for the spirit in which you followed the inquiry proceedings in whatever way you have, here in person, online, through the inquiry emails and wider media. I thank you with sincere appreciation for making this a collective endeavour, for the warmth with which you support one another, and for your kind words about the inquiry team and its process. Thank you all, individually and collectively. Thank you and goodbye for now.